Peace, peace, peace. Trust Christian. Own nothing, control everything. Just want to thank you for tuning in live, listening in on the replay, wherever you are in the world. Just want to thank you. Today, we're going to be talking about abusive trust, tax, private trust versus business trust. Or private trust versus public trust. We're going to be talking about trust today, as we always do. Because what we talk about is a lifestyle. We're not talking about some hipster scheme. But recently, I've encountered quite a few people that want to know about trustee training. That's what the Vault and Trust Christian provides. We provide trustee training for individuals that want to move into this form of lifestyle. I'm going to address some things very readily head on. I'm actually going to be coming straight from the IRS website. Surprisingly, a lot of people, people don't even know who the IRS is. The IRS is an accounting agency. Okay, Trust Christian, I'm not afraid of them. Okay, Trust Christian, just know that Trust Christian knows that the IRS is an accounting agency. Okay, so we want to be very clear. We don't want people to be duped in trustee training by having seduction by syntax, with words and things of that nature. We want to make everything clear that everything is commercial. That's why everything deals with penal, which is pecuniary, which means financial in nature. Everything in the United States, the world we live in, is a financial, commercial world. Everything is commercial. So we want to make sure tonight that we're going to have dinner with the IRS. We're going to eat with the accounting agency for the United States and move forward from there. So thank you all for tuning in live. Thank you all for tuning in the replay. Thank you, Bomo. So you all can Google this. You can go to the abusive trust tax evasion schemes. A lot of people say, well, why are we using trust? We're using it because we want to put ourselves and take advantage of the 4 keys of wealth, which the first thing is put yourself in the correct tax position. So you all can look at this. I'm looking at the talking points. This is coming straight from the IRS website. I'm going to let you all know that they actually mix in tax avoidance with tax evasion, making you seem like you don't know what you're doing when tax avoidance is perfectly legal. Tax avoidance is the use of legal ways to pay less taxes. So let's just go ahead and get into who's actually one of the masters of this. One of the masters of tax avoidance is the President of the United States. His name is Donald Trump. And this has been for all of the presidents. Okay? So let's just go. He said, I don't have any taxes to report. Why? Because he doesn't have anything in his name. He's legally practicing a way to avoid paying taxes. It's that simple. Thank you, Joyner Tier, for tuning in live. The Bake Show, thank you for tuning in live. He says, I don't have any returns to show. So we're just going to be very clear that, when we go over this IRS information today, that you all see that they're mixing in terms, saying that you can't avoid, or they're marketing, people are marketing, avoid and evade in income taxes. But one's legal. Avoiding is actually legal. I'll give you a case to start you out. It's Gregory versus Helvering. Let me pull this up. We're going to start out on the right foot. We're going to use Supreme Court cases. We're going to use court cases that tax attorneys know about. So when you ask your tax attorney about Gregory versus Helvering, it's a United States landmark decision by United States Supreme Court concerning U.S. income tax law. The case is cited in the fact that, guess what? Setting your affairs up to avoid taxation is perfectly legal. Gregory, Gregory versus Helvering, Helvering. It's a 1935 case. This is very early on after the tax code, income tax law was passed. Gregory versus Helvering. You all can see that case. This is what we go over in trustee training. This is how you become the best trustee. Now, let's just hop straight into it. Facts about a trust. Let me go ahead and bust it down to you right now. There's 2 different types of trust, but there's 80 different forms of trust. Okay? The 2 different types are they're public and private. Let me read to you how this is on the IRS website. They never told you that a trust is private. Why would they tell you that? They're a public institution. They're reporting public taxes. So let's see what they say. Facts about trust. A trust is a legal entity formed under state law. That is what they want you to know. Article 1, Section 10 of the United States says, no state can impair the obligation of a contract. A trust is a contract. So If it's created without the government, that's not under the state law. So, to create a trust, a legal title to property is conveyed to a trustee who is in charge with the responsibility of using the property for the benefit of another person called the beneficiary, who really has the benefits of ownership except for bare legal title. Okay, so we're not. I'm on the, once again, IRS website. This is talking about abusive trust. This is literally talking to you all about the deal, and we're gonna go over aspects of it tonight. So as you all can see, they said a trust is formed under state law. Well, how can it be private if it's under the state? That means it's public. See, public entities are LLCs, S corps, C corps, partnerships, associations. Those things are under state regulation. We're talking about private trust at the vault. We deal in privacy. We help clients and trustees protect their privacy. Okay? So let's get into it. And you all have to bear with me on the chat, just because I'm going to be bouncing back and forth with the chat and the actual website. It says, trusts are also being used to reduce income taxes through a variety of abusive techniques not allowed by the IRS code, Internal Revenue Code. Okay? To depreciate personal assets. I'm going to tell you the mistake there. And this is business, it's not personal. So as you listen to what I'm saying, a trust is a separate, distinct legal entity. As a trustee, you are trained to know that you are not dealing in anything personal. This is business. You as the trustee have a job. As a trustee, you do not own the trust. You are a trustee of it. That is what you go over in trustee training. For all you all that want to know what trustee training is all about. To depreciate personal assets, well, you would not be doing that. To deduct personal assets, you would not be doing that. It's not personal, it's business. To split income over multiple entities, often filed by multiple locations. To unreport income. Whose income? Personal or business income? To avoid filing returns. Why would you do that? The trust is supposed to file returns. It's a business entity. It's an entity collecting Federal Reserve notes or not Federal Reserve notes. If it's not collecting Federal Reserve notes, there is no tax liability. Why? Because it says reporting income. Okay. Trusts continue to grow. They're talking about the fact that they have all these different type of tax forms. So when I have individuals come to me and say, well, should I file the W-8 bin, and what tax form should I fill out? First of all, you're supposed to be in trustee training to know that. I'm not going to tell you that. No one from our team is going to instruct you on that. Why? Because why would you be doing something you don't know how to do in the first place? As you can see, they already told you that if you have a trust, it's supposed to be under the state. So that means you're supposed to go to a public attorney. We're not public attorneys. We're private trustees. It says there's multiple penalties. There's a risk of significant penalties if you fail to comply. For example, failure to file. So when individuals say, oh, I got a trust and I don't need to file because it's a foreign trust, there's still tax associated with it. It says there is no income tax advantages. Oh, really? Oh, really? Are you sure about that? There are no income tax advantages? I will give you what we know from trustee training. A trust can do something me and you will never be able to do. That means it can pass on its tax liability to its beneficiary. That is an income tax advantage. This is not legal advice, once again. This is a conversation from a private trustee talking to individuals, letting you all know, having a conversation through the chat. This is not legal advice. Why? Because in order for you to give legal advice, you have to be a lawyer. We're not lawyers. We hire those individuals. It says trust tax rates are higher compared to the 1040 and the 1120. It says in 2003, the 35% maximum rate is reached by trust. Individuals filing in a different bracket might be lower. So think about it. This is letting you know that they're commingling personal and business. Why would you mention the 1040? This is the information that the IRS puts out to put people in a position where they don't know anything, to not want to move and do anything, to put themselves in a position. Who do you think wrote the Internal Revenue Code? Rich people wrote the Internal Revenue Code. The Internal Revenue Code does not allow trusts to operate a trade or business. Really? Then why would it be reporting income? Businesses report income. Natural living beings, private individuals don't report it. But because you have a trade or business that's effectively connected with the United States, because you're receiving Federal Reserve notes, or the entity's receiving Federal Reserve notes, guess what? That's called a minimum contact. That is a legal term. Minimum contact. Okay? The regulations require that a trust to operate a trade or business to be treated either as a corporation or a partnership. So this already lets you know that these entities are being treated as corporations, that they're being treated as partnerships. They enjoy the same immunity of being able to file bankruptcy. You're aware that corporations can file bankruptcy, partnerships can file bankruptcy. Grantors are treated as an owner. So let's go ahead in with these individuals that come to me and say, oh, I got a living trust. We're going to go ahead and put it out there for you all. For you individuals that have a living trust, you still are the owner. You did not give up ownership. That is a statutory, that is a legal public entity, because you, the public citizen, have not given up rights to the property. So it's not a separate, distinct legal entity. It's not a business entity. It's a personal entity. You're just putting assets in a separate place. All right, Blake, I'm back on the chat. Question: if a trust is a religious private trust, would the government have jurisdiction over it? So let's just address this question. First of all, the United States Constitution, what is that? Right to contract is in the Constitution, just like the religious freedom of religious part. So no, they don't have jurisdiction. Why would you call it a religious private trust? Is it because the religion has a private entity? And if it does, that's fine. Once again, you called it private, so that means it's without government. It can't be called private if it's with the government. Period. The grantor is treated as the owner. Well, guess what? If a public citizen opens up a trust, then that's considered a grantor trust, which is a living trust, which means, here we go, this is IRS right here, grantor is treated as the owner, therefore taxable on income generated by the trust. Wow, so the trust is not going to be taxed, the grantor is. Where the grantor is considered the substantial owner and enjoys the benefits of the corpus or the income from the trust. That's why you see most people that have living trusts, when you talk to them about this information, they're still filing 1040s. A trust, they just mentioned at the top, it files a 1041. Okay, here we go. Tax courts, federal courts, and bankruptcy courts have been virtually unanimous in finding for the service where trusts are created to avoid income taxes. It tells you right there, that's what they're created for. But guess what? If you don't know the difference between a public one and a private one, we might have an issue. Currently, there are two types of abusive trust arrangements being promoted. They got the domestic package and the foreign package. Right. The domestic package involves a series of trusts formed in the United States, while the foreign trust packages are formed offshore, outside the jurisdiction of the United States, and there is a period. So that means that one of them they actually have jurisdiction over, the other one they don't. But then they go on to say, well, the trusts are involved in both schemes are vertically layered, with each trust distributing income to the next layer. The goal is this layering distribution of income to reduce income tax to nominal amounts. They're giving you keys, but they're not telling you if it's really actually working for some people or if it's not. They're just telling you these are the abusive aspects that people are abusing. Keyword, do you hear the word abuse? This doesn't mean that it's not legal. Did you say this is illegal trust activities? No. They're not telling you the illegal activities, they're telling you the abusive. People actually tend to abuse the fact that they can layer these entities. That's what they are letting you know. They're putting you on notice. Hey, we're not telling you can't layer this situation here, but people usually abuse this situation. Promoters of abusive trust arrangements use a variety of methods to advertise their schemes, including seminars, flyers, and the internet. Right. The main selling point of abusive, keyword abusive, they're abusing trust arrangements, is to give the appearance a person is giving up control of their assets, and when in reality they still control how the money is an asset and the assets are used. So, I get people say, oh, I have an irrevocable trust. Look, I'm not going to tell you proprietary processes that the vault and the trustee training has. That's private. Okay, but I understand. I will tell you this, that yes, if you put assets in a trust and then you actually try to slide back in as the trustee, that is correct. You you're doing something wrong. You're abusing the fact that a trust can be created, and you're sliding back in as the trustee. How can you have gave up assets irrevocably, but you're sliding back in as the trustee? That's not how it works. So yes, the IRS is going to eat you for breakfast every time. So when you all contact the vault or Trust Christian and you say, well, yeah, I created a trust, I'm going to tell you right now, at the vault and trustee training, we do not create trust. We are trustees. We understand the proper position to be in from the beginning. We don't need to be in a position of, going in and creating trust. The information of what we're talking about, if you don't even have the proper education, you wouldn't be able to even move forward in the proper capacity. This information is private. The IRS is just putting people on notice to let you know, hey, if you do it wrong, we're going to eat you up. The public should not be misled by the word trust. Mere association of the term trust with the financial arrangement does not make it a legitimate trust. Let's go ahead now. False claims used to promote abusive trust arrangements. False claim. Establishing a trust will reduce or eliminate income tax or self-employed taxes. Correct. Because at the vault, at trustee training, you don't set the trust up yourself. That's how we do business. We understand how to do business from the correct position. That's proprietary. That's private. So we don't promote to individuals, yes, if you come into trustee training and you get this going, then you're going to eliminate a tax liability, or you're going to reduce the tax liability. You want to know when you say the word you're actually talking personal? Well, guess what? There's a difference between a business tax form and a personal tax form. 1040, that's personal. 1041, that's trust. 1120, that's corporate. We're talking business, not personal. Truth. The transfer of assets of a trust will give the donor no additional tax benefit. Taxes will be paid on the income or the assets held in the trust, including the income generated by property held in trust. The responsibility to pay taxes must fall on the trust. Oh, here we go. The beneficiary or the transferor. The beneficiary. So when they said there was no income tax benefits, I mentioned to you all earlier that a trust has the unique ability to pass on 100% of its tax liability to its beneficiary, depending on what type of trust you use. Right. Or the transferor. False claim. You can transfer income into another trust, thus eliminating income tax on that income. Oh, really? But didn't they mention earlier that people layer these entities? And didn't they mention that they didn't say it was illegal. They said it was what? Abusive. So they didn't say you couldn't do it. They just said it's abusive. You will retain complete control over your income and assets with the establishment of a trust. Well, that's a false claim they have, that is. Well, if you actually create a living trust, yes, that is the case. You still have control. You didn't give up assets. They just said you didn't give up any assets. You just basically put it in another entity and tried to avoid taxation for a short period. But in turn, you didn't give up control of the assets because it's a living trust. Listen, this is what they're telling you. False claim. Taxpayers may deduct personal expenses paid by the trust on their tax return. You're right. It's not personal, it's business. Nothing is in your name. So how can it pay for any expenses for the individual taxpayer? How can it do that? But you're not educated in the information, so that's how you would know. Taxpayers can depreciate their personal residence, keyword personal, residence, and furnishings, and take them as deductions on their tax return. So how is it that a trust is going to pay for your personal so-called situation, and you as individual taxpayer are going to be able to report that as a deduction on your personal tax return? That is correct. You will be quote-unquote hemmed up. You will be quote-unquote eaten for breakfast by the IRS. They will eat you alive. You cannot do, it's called commingling. In trustee training, you learn two things. You learn how not to commingle, and you learn not to do fraudulent transfers. That is what you learn as a trustee. That is what you learn. It says they take these abusive trusts. Do you hear the word abusive? They're not saying illegal. Why are they not saying illegal? Illegal is illegal. Legal is legal. We want to be very clear about that. They said illegal. but they said abusive. They didn't say illegal. So I'm going to go to one of my favorite sections. Abusive trust, tax evasion schemes, special types of trust. Here we go. I'm going to break it down for all the individuals out there. Oh, I got a common law trust. Oh, I have a non-A number trust. There's no such thing as a non-A number trust. Okay? I have a foreign trust. Well, if you have a foreign trust, well, I'm going to read it to you. What the IRS says. Contrary to claims of promoters, so when individuals telling you they're selling you a common law trust, no longer exists since all states have statutes regulating the creation and operation of trusts. Once again, ladies and gentlemen, every state is under the common law of England except for Louisiana. Okay? A trust is a contract. If they're under the common law of England, they're under the common law of contracts. It says, Article 1, Section 10, no state will impair the obligation of a contract. This is privacy. This is private trustee training, not public statutory. There's a difference. I told you, there's public trust and there's private trust. How can they create a thing called a private corporation? How can Donald Trump say, well, I don't have to release those records? He's in a public office. He's not in a private position. He's in a public office. That's because his affairs are put in a place where they're private, not public. He doesn't have to release his records to the public. Through 1996, a trust was foreign if the trustee corpus administration were foreign. Since then, they've tried to put all these other quote-unquote positions in place. But foreign trusts have income attributed to the United States and are not grantor trusts, are required to file. They're still required to file if you receive an income, or if the trust receive an income, the actual they want you to file a tax form. Which is perfectly fine. There's nothing wrong with that. You can't go into a financial jurisdiction and then not account for it. I told you, the IRS is an accounting agency. Nothing more, nothing less. People try to call them a collection agency. First of all, where do the income tax return checks come from? They don't come from the IRS. They actually come from who? The Treasury. Simple. They're an accounting agency. Personal residence trust involve the transfer of personal residence to a trust where the grantor, see, this is called your living trust, is grantor. Grantor didn't give up rights, retaining the right to live in a residence for a fixed term of years, and then yada yada yada. This is a irrevocable trust with tax implications. How is it irrevocable if you didn't give up rights to the property? Come on now. Grantor retained income trust. Grantor retained annuity trust. Grantor retained unit trust. Let's go to charitable trust. A lot of people think they're going to get around this whole situation with these charitable trusts. I see people talking about this all the time. A charitable trust pays okay, here we go. I got to make sure I'm at the right one. We're going to do a charitable remainder trust. Let's do a charitable remainder trust. In a charitable remainder trust, the donor transfers assets to an annuity trust or a unit trust. That's public, okay? Not private. The trust pays the donor or another beneficiary to a certain amount of money each year for a specific period. I keep telling you all, if you, as a trustee, you're not even in a position of trustee. If you give a trust assets and you hold on to them, guess what? You are commingling. Okay? There has to be a thing called arm's length distance dealing. Period. They got life insurance trust. They got funeral trust. They got rabbi trust. But let's go to this thing called a business trust. Because everybody says, oh, you know, I've had some trustees come to me recently. They went into the deal with this bank. The bank said, there's no such thing as a business trust, and we need to know what state is incorporated in. Okay? The term business trust is not used by the Internal Revenue Code. This is on the IRS website. Okay? The term business trust is not used in the Internal Revenue Code. The regulations require that the trust operating a trade or business be treated as a corporation, partnership, or sole proprietorship if, keyword if, the grantor, beneficiary, or fiduciary materially participates in the operation or daily management of the business. You see how they have an if? They want it to be treated as a domestic entity. because it's materially participating in the operations of the daily management of the business. If the grantor maintains control of the trust, then grantor trust rules apply. Wow, sounds like a living trust to me. Here we go. Otherwise, the trust will be treated as a simple or complex trust depending on the trust instrument. That is the code. Do you know the difference between simple and complex? Do you know what a trust instrument is? The average individual doesn't. The average attorney doesn't. Why? Because they're educated in public statutory information. Statutory meaning that they got their law degree, they're educated on a public level, and they're only administering trusts that deal with the trust in that state. They're not dealing with international entities. And if they are, their services are going to cost quite a bit. I have individuals come to me and say, oh, we're dealing in a pure trust. Well, tell me what a pure trust is. Well, I'll tell you what IRS says about the pure trust. The term pure trust is not used in the Internal Revenue Code. You see how business trusts and pure trusts are not used in the Internal Revenue Code? But they didn't say that you couldn't do business with the trust. Did they say that? You can rewind this on the YouTube. I'll show you do this when I transfer this over to iTunes, and it'll be on the podcast. Did they say that the trust can be used for business? And they said if it is, it has to be treated in a specific manner if there's X, Y, and Z going on. This is called understanding how to read. A pure trust is not used in the Internal Revenue Code. Whatever the name of the arrangement, however, the taxation of the entity must comply with the requirements of the Internal Revenue Code. The requirements are based on the economic reality of the arrangement, not its nomenclature. If the pure trust meets the definition of a trust, then it would be taxed under simple, complex, or grantor trust rules, depending on the trust instrument. Do you understand the power of the trust instrument? So remember, if it's a private contract, which is the trust instrument, that means it's without the government. So that eliminates a lot of the regulations that we're reading over today. There is a difference between public and private. Donald Trump is proving that to you. It's up to you whether you want to be educated on it. Private trustee training. Christian at trustchristian.com. Unincorporated business organization. I get a lot of people talking about this unincorporated business organization. These are called colloquial terms, just like a Massachusetts trust, just like a Delaware trust. They're colloquial. That's not an actual term per the IRS. A term used by trust promoters to identify trust they sell to disguise the fact that it's a trust. Okay, sure. The term Massachusetts trust, Massachusetts business trust, are often used interchangeably. These are not terms used by the IRS, the Internal Revenue Code. As you all can see, did they acknowledge private trust at all? You all can look at these pages on the IRS. All you gotta do is Google abusive trust tax schemes. Let's go to the Delaware Trust and the Alaska Business Trust. The trust established to hold investment assets with greater flexibility allowed than most trusts. These business trusts, this is actually on the IRS website. So earlier in the page they said there's no such thing as a business trust. But in this particular Delaware and Alaska business trust, they actually mention it. And it's in quotations. These business trusts. Because no one's saying that a trust can't do business. They're just not acknowledging a business trust. These business trusts have no special distinction in the Internal Revenue Code and will be, once again, a simple, complex, or grantor trust, depending on the terms of the trust instrument. Do you see how they keep going back to the trust instrument? So you actually have to know specific language that's supposed to be in the trust instrument. That's either public or private, people. The regulations require that the trust operating a trade or business be treated as a corporation, partnership, sole proprietorship if the grantor, beneficiary, fiduciary materially participates in the operations of daily management of the business. Filing requirements would depend on its classification. Oh, so there are trusts that may or may not have to file depending on their classification. Yes. Yes. So, as we all can see, I'm going to come back to the chat. Let's see who's on the chat. The Bake Show says, would you have to record a private trust with the county? So, the Bake Show. Let's be very clear, the Bake Show. If it is private, what is the county? The county is public. The county has a public record. Why would a private trust be on the public record? It's private. This is what you're either going to learn or you're not going to learn in trustee training. So, let me see if I can pull some more stuff out of here for you. We got to try to pull out abusive trust tax schemes. You all can ask more questions. I definitely don't have a problem with any questions. Big Show, great questions. So yes, I think I covered it. I could easily go to business structures. I can go to the IRS website. We're on it right now. They're talking about abusive trust tax schemes. But I'm just pointing out to you all that they're not talking about private trust. They're talking to you all about public trust. So I'm going to go to business structures. Okay. This is for the layman, somebody that wants to start a business in the United States. Somebody that has no knowledge of business in the United States. If I say, oh, I'm coming out of high school, want to start a business, let me share with you all what the IRS says about business structure. See, this is where you go for the accounting for the business so you don't end up in some type of tax situation. So you can actually go talk to your CPA and they can actually do their job correctly. Because as a business owner, you hire CPAs. Okay? You don't work for them, they work for you. You hire a tax attorney. They work for the business. This is business structures. When beginning a business, you must decide what form of business entity to establish. Okay? You form a business. Your form of business determines which income tax return you have to file. The most common forms of business, here we go, common forms, right? Common meaning public. Business forms are sole proprietorships, partnerships, corporations, S-corps, period. A limited liability company, LLC, is a business structure allowed by state statute, period. Legal and tax considerations enter into selecting business structures. Here we go. Sole proprietorships, partnerships, corporations, S-corps, limited liability companies. It says, for additional information, refer to the Small Business Administration. Choose your business structure. Where in that did it let you know that you can operate utilizing these entities? How would you ever be able to create a private corporation if you don't know about how to create anything privately without the government? That's what private means, without the government. It's private. The contract's created privately. Article 1, Section 10. So, that is what we're talking about. Trap Money says, is the UCC one necessary? Not at all. Because the UCC is dealing with Uniform Commercial Code, and that's public. It's a public notice. Would trademarking your name as well as your business name be helpful starting a business? Or would trademarking your name, okay, as well as your business name be helpful in starting a business? Remember, you say your name, that's personal. Okay, it's business. Once the business name's created, it is a trademark because it's a mark operating in commerce. Now, if it's public, it actually has a lot more of protection because the state's not going to allow you to open up something that's not actually protected. And the fact that it's opened up on a state level, they're going to protect whatever entity with that name is opened up first. So there are some benefits to having things open up on the public side as opposed to private side. You can trademark things privately for sure. That's without the government. But the reason why sometimes even when I talk to trustees, sometimes it's beneficial to copyright things in the public from the private capacity because there's a common law copyright and then there is a public copyright. The Copyright Office and the Trademark Office do acknowledge common law copyrights. It's rather challenging to enforce them, but they're gonna put it through a lot more litigation, and they're automatically are going to defer and default to the public filing first. But after they go through litigation, after they do their research, find out who was actually utilizing the patent or the trade name or the copyright first, that's when they'll make their ruling. But in the initial onset, they definitely will make their ruling based off of the fact that someone made it a point to file with the public enforcement agency, which is the USPTO. They're gonna side with them first. So it is beneficial to deal with them in that respect, because they're gonna side with the entity that filed first. So that's the good thing about the USPTOs. They're going to enforce whoever filed first. But like I say, they do acknowledge common law copyrights. You can look at that on their website, and they're just going to go do their due diligence and go through litigation and things of that nature to see who actually really used it first, who has beneficial rights, and and you can settle the matter privately if you choose to, and things of that nature. Thank you, Bake Show. I'm glad you're learning something. This is what it's all about. It's understanding the difference between public and private. Okay, and once again, there is a Supreme Court case that hasn't been overturned, so we shepherdized the case. It has not been overturned. It's called Gregory versus Helvering, Helvering. This is a Supreme Court case. Okay, in trustee training, you learn that the Supreme Court carries the same weight that the IRS code carries. They go hand in hand. Okay, so this case that says setting up the affairs of any person, quote unquote, a person is a legal person, which can be a corporation, S corp, C corp, trust, or an individual taxpayer. That's a person. That's why they call you, what's on your person, what's the legal person's name. Okay, so affairs can be set up properly to where tax avoidance is perfectly legal. That is what that case is all about. That's what you learn in trustee training. So this is what we do in trustee training. We understand how to protect privacy. We understand that there's multiple entities. Family wealth is passed on through private families, not public families. Public families get slaughtered. Public families go through probate or a thing called intestate. Okay? So we're not doing anything abusive. In keyword, it said abusive. It didn't say illegal. So it's already letting you know they really have a loose governance over it. But they are letting you know that if you do this, we're coming to get you. If you do this, we're coming to get you. And all of it had to do with a monetary aspect of it. Filing, reporting, proper distributions, assets in general being accounted for. This is business. It's not personal. So that is the situation that you all are running into, is the lack of information. And guess what? It's not the IRS's job to tell you what you can and can't do. Bake Show says, how do you find these private CPAs, lawyers, and accountants? I've been looking high and low. More high, though. Well, once again, they call themselves private. So why would you know about them? You know what I mean? Like, I understand that I, Trust Christian, is sitting here talking to you all about private information, but I also can tell you that contracts are public and private. A trust is a contract. There's public and there's private. So to find a CPA, what I would say is to lead you in a better direction is that what you would want to look for is estate planners. Estate planners are the people that are usually going to be able to kind of walk you a little bit somewhere down a path, and once again, they're still public if they are dealing in that public capacity. Usually people that even deal with what I'm talking about, they give up their bars. They give up being a bar member. Why? Because they don't want to be looked at legally as someone that has to adhere to some type of licensing policies. Okay? That's what we're talking about. Because licensing has to deal with the United States government. Privacy means no state can impair the obligation of a contract. That means that me and you can create a private contract and do things privately without the government. Yes, that is happening every day. That's why they call them private corporations. That is why the president says, oh yes, I don't have to report any taxes, because guess what? I don't have any tax liability to show, because I don't personally have any money coming to me, and that's that. And he doesn't speak any further. That's simple. Thank you, D, for tuning in live. So I'll take some more questions. Otherwise, I don't need to be long-winded. This episode is for inquiring trustees to want to know about trustee training and understanding that It's all about owning nothing, controlling everything. It's all about being a trustee and a steward of life. Okay? And no, we don't create trust where we create the trust. We don't create a trust. It just said that if you create the trust, you're not giving up ownership generally. That's right. So you have to be instructed a specific way. That comes from knowing private people. And I'm not planning on doing this for the rest of my life. I will be a trustee for the rest of my life. I was instructed by a private mentors, and we came to the conclusion that they came to the conclusion long before I did. That's why I know it. They came to the conclusion that just because you make a certain amount of money should not mean that you are privy to this certain information, private information. So I've made it a point as a trustee to steward and be a trustee over the information and create trustee training. Period. So we're not some huckster selling trust. We're trustees in training, as you will always be. She says it only D, and hopefully that's a man or a woman, but it says it only makes sense since the operator of the trust is responsible or liable for that operation. Well, it's responsible, but it depends on what they're responsible and liable for. Once again, if the trust is a separate, distinct legal entity, then we have to repeat that again. It is a separate, distinct, legal person. That means that the trustee or the operator does not own it. They are just a trustee. That is the position that you must understand and know, is being a trustee, not being just a owner or what we call operator. You want to be known as a trustee. Everything is TTEE per the IRS. So I'll take some more questions, but for the most part, ladies and gentlemen, it's all about doing business from a private capacity. Joiner Tia says, is it safe to say that private means not using your social security number? I would say that, so, I mean, when you think about it, if you have to get a driver's license or a passport, and I even have trust mentors that don't even agree with that to a degree, but that's neither here nor there. But point being that means that your social security number, or excuse me, not your, but the social security number is not operating in commerce as far as generating income. So in turn, it will be private. You will be private. You'll maintain your privacy as a natural living being because you're not operating in commerce. The social security number that was given to operate in commerce is not being utilized to generate income. So it gives you a high level of privacy. Once again, same thing with Donald Trump. You think he doesn't have a social security number? Every citizen has a social security number. The only difference is he's maintaining the wealth privately because he's not utilizing that social security number to actually generate the wealth that clearly he's taking advantage of. I mean, the guy's riding around in nice cars, nice suits, private jets, all of those things previous to him becoming a private president. Tanisha, thank you so much, and I appreciate you. Alice Castro says, how can the trust benefit my LLC business? Well, once again, you calling it yours, so that means it's personal, which means right now you're probably personally liable for the money that either the trust can't, that the LLC is because the trust is, an LLC is looked at as a pass-through entity. So the LLC is either going to be taxed as a corporation, or you as the owner of the LLC is going to be taxed. Well, a trust is a separate, distinct legal person. So what it can do is it can take on that tax liability, and it eliminates you from the previous question, which was if you're not using your social anymore, that's how you maintain privacy. I can guarantee you all that Donald Trump, the entities that he utilizes are traditional. You're going to see the trust own LLCs. Why do private trustees use LLCs? To make sure that they don't alert the public, and to make sure that the public doesn't see that they're operating out of a private trust. That's why they use LLCs. And the LLC is some type of public buffer. It's a public statutory regulated entity. There's regulations to the LLC on a statutory level that give it benefit for suit and things like that. And so it makes it easier to establish credit on LLCs and things like that. But the trust will benefit it because the trust is a person, so it'll own it. That's the benefit. The trust owns it. That's how. And in turn, the trust, deals with it from that aspect as far as the benefit, because the trust is a legal person, so it can own the LLC and not you. And that changes what you would consider as the tax situation. You're welcome, D. Can you use a promissory note even not getting your birth certificate authenticated on a federal state level? Can you use a promissory note? What is the purpose of utilizing a promissory note? I don't get that. Like, we're talking about private trust. We're not talking about the assets. We're not talking about a birth certificate. We're not talking about anything public. We're talking about private trust, not a promissory note. First of all, in the private, you're not promising anything. You either have the substance or you don't. In the public, they deal with debt. That's why people can go to school and get a $100,000 student loan, which is nothing more than a promissory note. First of all, the government doesn't make anything. So how did the government give an individual taxpayer money in the first place? They created a promissory note, which, this is what I'm telling you, they created a promissory note, same thing with a mortgage. They created a promissory note for that individual to pay money back to the government. That was created out of thin air. That's the public. We're not talking about that. We're talking about the private. You don't create promissory notes in the private. There's no IOUs in the private. You either have the asset, you have the collateral, or you don't. That's why most people won't make it on the private side. It's because they're trying to avoid being accountable to what is it that's really going on in the world. Keeping your word or doing business the proper way, which means you actually have the substance. This is not the stock market. This is not an ETF. This is actual substance. This is gold and silver. Article 1, Section 10, not only does it protect your right to contract, it says what? That they actually hold gold and silver as real money. They never say that real money is promissory notes, the Federal Reserve notes. D says, is my, oh, your initial spelled out. Okay, cool. Tanisha Swinton says, is a tax ID number the same as a social security number? It's a taxpayer number. It says a tax ID, and the social security number is identified as an individual taxpayer number. So you can put two and two together and know that they are it's an entity number that's reporting, because if it gets money going to that number, then it's reported. It's supposed to be reported. Bayshow says, it is so hard to find trustees if you can't trust anybody. Well, that's why, you know, in trustee training, that's the first thing we make sure that you focus on, is finding successor trustees. That's why we have the private community, so you can find other trustees that you can actually trust. That's what trust is all about. That's the distinction, is being inside a trust. It forces you to find somebody to trust. That's what trustee training is all about. That's why people won't contact the Vault or Trust Christian. They won't contact just because they don't trust us. And I understand that. Why would you? You don't know us. Well, guess what? It's a thing called faith. Faith is doing things without seeing things first. It's the same thing with a trust. That's the same thing with privacy. You don't see privacy going on, but guess what? Every time they hop on the TV, the government will sit there and tell you the private sector is doing just fine. Well, how come you don't know what the private sector looks like tangibly? It's called contracts, because contract law is private law. Bomo says the difference between the social security number and the EIN. There's no difference. They're tax reporting numbers. Tax means it actually incurred an income, so it has a tax liability now. That's it. Says Tribe Money says, is SPC secured party creditor something to look into? They're a organization or more saying to do the UCC 1, 3, and 11. Oh, I'm very familiar with these type of groups out here, Tribe Money. I know all about it, and I can tell you right now, they don't understand business. It's business. It's not personal. That's the problem with individuals. They're commingling business and personal. We're here to do business. That's it. That's called public. But in your private time, the government doesn't need to know your religion. The government doesn't need to know what sex you are. They don't care. They want to know what they can tax. That's the only reason the government is around, is to protect and tax. So, is it something to look into? I'm not going to tell you that it's not. You should look into whatever you want to look into. But what I'm going to say to you is a lot of that organization that you're talking about, I can tell you right now, we're talking about business, and they're clearly not talking about business. They're talking about protecting yourself personally. Guess what? I'm not talking about personal. You want to know how you're protected in personal? Don't enter into commerce thinking that you're entering into commerce, because you're not. You're never. The natural man is never in commerce. It's called a legal man. It's a legal person. It's statutory. It's called a social security number. You were born without a social security number. That's why they call it a legal name. When you go get a Black's Law Dictionary, you will see the terms. This is why law is not taught in school, because it is commercial. Law is commercial. Contracts are commercial, public or private. So ultimately, does one want nothing but trustee training and not only know how and why to set up a trust, an LLC, etc., but to also utilize and protect one's uses of one's... you got to make sure. Let me know what TDA means, D, because I want to be clear about that acronym. But what you're asking here when it comes to trustee training, look, trustee training is provided for people that want to live their life from an own nothing, control everything perspective. That's it. If you are not able to grasp that concept, don't worry about it. Keep it moving. Enjoy your life. I'm sure you're going to own everything. I'm sure you're going to be available to get sued. Why? Because it's you. In trustee training, it's not about you. It's about the trust. Because you're administering as a trustee the trust. It's own nothing, control everything. The trust can go own the car. But guess what? Can the trust drive the car? No, so clearly you, the trustee, will be using it for the benefit of the beneficiary. So it's still not even to benefit the trustee. It's for the benefit of the beneficiary. This is what you learn in trustee training. It's to put yourself in a position where you understand private trust and public trust. It is to also make you aware of when it is good to use LLCs or not to use LLCs. Why? Because I mean, come on now, the LLC is a public entity, so there's some benefit to these public entities. Google and Amazon are all owned by private companies, private holding comps, but they don't tell you that it's a private trust. It's that simple. That's how they're able to operate in Europe right now and not pay taxes. They're going through an antitrust lawsuit. But you all think that Google's doing some type of specific schemes on not marketing people properly. It will be called the business practice suit. It's not. It's called an antitrust lawsuit. It's the same thing that Bill Gates went through with Microsoft. It's an antitrust lawsuit. That means that there's a trust involved and they're trying to break up what's considered a monopoly. Why? Because the trust isn't paying taxes. He knew what he was doing when he set it up. And then, once he went through it, guess what? He set up at the end of that whole lawsuit with the IRS, he set up the foundation, the Private Family Foundation. And the webinar that me and Douglas Easy did recently, we showed the Private Family Foundation that he actually created and that he administers. He doesn't draw any salary from. Him, Bill, Melinda, and Warren Buffett, they all sit on the Bill and Melinda Gates Foundation, and they don't draw any monies from the entity. But guess what? His dad is on there. His mom is on there. And they're pulling 100K plus. They even got the chef making 100K. Why? Because they understand how to remain tax avoidable. They understand legal persons. Bill Gates knows this. You're welcome, Bomo. You're welcome, Jordan Tia. So let's go back to your question, D. So ultimately, does one want nothing but trustee training to not only know how and why to set up a trust, LLC, etc., but to utilize and protect one's uses of one's treasury direct account? And I get that. Look, ladies and gentlemen, I understand that there's a lot of people that have been Googling things their entire life. I wasn't born with Google, but I also use Google. Yes, I do use Google. And what I'm actually talking about in trustee training, none of our stuff is on Google. It's private. Anything that's on the internet is public. So this whole treasury direct account information, the people that deal with what I deal with, I'm gonna repeat to you again. The treasury is dealing with the government. So that means it's not private. So we have no interest in the treasury direct account or the birth certificate bond. All of those things are public. We're talking about administering your life from a private capacity and learning how not to incur tax liability or have the ability to be sued. That's it. So Tanisha says she just grabbed her Black's Law Dictionary and there is so much info in trust. It is, but I would also share with you, I've also shared with you, Tanisha, that a trust is a contract. So you're going to expand yourself even further when you go into the contract section, when you understand certain elements. That's the purpose of trustee training. Really proud of you, Tanisha. I will say that I'm proud of you. Any of you all that have grabbed Black's Law Dictionary, any of you all that have taken some steps to further your education, the first thing is learning the language. That is the defeating aspect that you have right now. You do not have a verbal game when it comes to understanding certain things. And so the Black's Law Dictionary is going to speed you up. That's what I read for years. I still read it on a daily basis. JLA, JLH, get a law dictionary. Definitely have to get a law dictionary. Why? Because that's not something that's taught in school. How can you hire a good lawyer if you don't even know the language that they're supposed to be speaking? They're telling you one thing, you don't even know what it means. And you're hiring them. You're paying them. They're not paying you. You're not their employee. They're your employee. Let's act like it, entrepreneurs. Bayshow says, will you be offering any kind of discount or special offering for trustee training because I'm balling on a budget? Interesting question, Big Show. And this is what I will say to you. There is no discount in life. I have never heard of a free lunch. I've never heard of a special offer. Okay? It's one offer. Take it or leave it. That's the same thing the government gives you on the public side. It's called an adhesion contract. It's called take it or leave it. Adhesion, ADHESION, adhesion contract. Take it or leave it. Trustee training is provided by the Vault and Trust Christian at its own risk. So no, there will never be a discount. You will never be discounted on private anything. There's no discounts in the private. There's only tax cuts and propaganda in the public. Special offers in the public. So Jamie Martin says, why not set up an LLC to deal with the Treasury Direct account and transfer it to a private trust? Okay, once again, you're commingling public and private. Why would you be transferring anything from a public, sending it and transferring it to the private? The IRS, I just read that earlier in the presentation, that when things are transferred from the public to the private, there's going to be tax liabilities. So you have to be instructed in a specific way on how to actually do these type of things, and not just do it because it sounds good. And why would you be wanting to deal with the public? See, this is the mentality of individuals, and I'm not talking specifically about anyone here, you all. I'm talking about a mentality. Don't take this personal. It's business. This is the mentality of people that have been given things their entire life. When you are coming from the private, you don't own anything. You control it. So that means you have no problem with going out and starting from scratch. Whether that's your education or whether that's from ground up with assets in general. You start from scratch. You go from zero to hero. You don't need a handout. Tanisha says the language is what gets me every time. Well, that's why you got to read the law dictionary for sure. Own nothing, control everything. Thank you, Tracy, for tuning in live. I appreciate you. Commingling, anything's not cool. I'm going to take a couple more questions and then I'm going to get lost here soon. So thank you all for the questions. D says, so if one wants to utilize public scores, one might as well remain a public entity. If, for instance, one wants to use fiat, benefits, etc. on the public side. Once again, there's a such thing as called private corporations. So it's just if the entity or the quote-unquote person, because that's what an entity is a person, if that entity is dealing with fiat, which incurs a tax liability from income in general, that doesn't mean that it can't hold assets. Can a corporation create a credit score? Yes, it can. You see that all the time. So there are some benefits. There's not a complete lack of not being able to operate in the public. Once again, the president is sitting here telling you, I'm in public office, but my records are private. Simple. Jamie says, is nothing wrong with paying less taxes through the LLC. That's your prerogative. But we're talking about rich people that don't pay taxes at all. So what are we talking about here? If that's what a person wants to do, have fun. No one's stopping them. Nonprofit Communication says, do you help with education on how to acquire assets such as land or vehicles in one's proper position? As a trustee, that's your job. Your job is to acquire assets for the trust and grow. You're a fiduciary. So your first responsibility is to grow the assets that were previously placed in the trust from the beginning. So yes, whether that's land or vehicles or whatever, that is your quote-unquote job as a fiduciary, as a trustee. So yes, that's in a part of the educational program as a trustee, is to learn how to do those things, and do those things effectively, and from that perspective. D says one should still set up an LLC under their name. I don't know if that's a comment or a question, but I don't see the benefit of that. I don't, because we're talking about it from a private and a public perspective. I'm talking about it from a private perspective, so I don't see how that would be a benefit. And if you can't explain why that would be a benefit, and why would you be doing it under your name, that means you still own it. That means you created it. So that means you're tax liable. Simple. This is not hard. This is basic, simple. 1 + 1 = 2 information. But I understand we've been given a public education. They say we can read, but they say we can't comprehend. That's why we're supposed to learn how to comprehend. It's reading and comprehension, not just reading. D and B, I guess you're talking about Duns and Bradstreet. D, not necessary. Once again, if you want to, if the entity is going to report on Duns and Bradstreet, perfectly fine. No problem with that, because it's doing business, doing business with other vendors. It's business. It's not personal. That's the best part about D&B, is it's reporting business credit. So it is a great aspect to deal with. I'm going to take the last question here. Thank you for public sources making confusing. I agree with you, nonprofit communication, 100%. Jamie says, or setting up foreign LLCs to be beneficiaries. So first of all, when you say a foreign LLC, that means that it was created in another jurisdiction under a LLC is public. It is a public entity. It is created under state statute. When you replay this episode, you will hear what the IRS says, not what Trust Christian says. It says that it is created under statutory regulation. That means it's public. So why would you set up a foreign LLC to be the beneficiary? Why would someone do that? You said set up a foreign trust? Okay. All right. Just had to make it clear. So you said set up a foreign trust to be the beneficiaries. There we go. Now we're talking streamlining. Now when you go back and you listen to the episode and you see where the IRS says people are abusing the fact that you can set up layers. Oh, okay. Now you see where foreign entities are layered. And particularly trust, because they're contracts. So yes, Trust Christian is the name. Own nothing, control everything is the same. That's the whole position. That's the whole game. So thank you all. I usually don't do an hour, but I really wanted to bless you all and give love today, because I have a lot of people that want to have a lot of clarity, and I appreciate the questions. You all rocked it today with all the questions. I will be on the Vault page. I'll post this on the Vault page on Facebook. I will be doing some stuff on Facebook this week under Trust Christian, so just feel free to go to the Facebook page. And this is it. This is the difference between a public education and a private education, is understanding contracts. And that is what you understand, your family learns, so we can get back to, quote unquote, making America great again. You got to make America great by making your family great. And family law is private law. Contract law is private law. You got to do that privately first. You can't make the group better until you make the private situation better first. So thank you, JLH. Peace and love. Appreciate you all. You all feel free to enjoy the rest of your day or night. Share this with your friends and family so they can get that education with you. Don't be stingy. Share it. And I do appreciate you all sharing. I look forward to hearing from you all in trustee training. If you want to contact via email, email is for trustee training. It's not for you all to ask me more questions and try to get a consultation via email. Either getting a consultation or you're actually enrolling in trustee training. Okay, that is the only reason that Trust Christian and the Vault is even doing this, is to make sure that we can ensure our private community and maintain privacy at all times. So Christian@trustchristian.com. Look forward to hearing from you. Otherwise, I'll look forward to hearing from you on the public airways. See you soon. Peace and blessings.